I don't give up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, if you're going to look at this judge and think I can't do something, young man, you're going to learn a big...
Court calls the case of the people versus Marquesi Hankey.
We have you, Your Honor.
Good afternoon, Your Honor. Attorney Kevin Masson, P. 711.
Right away, you can tell this isn't an ordinary bond hearing. The entire case comes down to one question. Can a judge trust someone who's already ignored the court once? In criminal court, violating bond conditions is one of the fastest ways to lose a judge's confidence. Do you think everyone deserves another chance, or should one serious violation be enough?
All right, it's your motion.
There's probably a motion with respect to a previous PTC hearing. My client's bond was revoked from privileges from the jail, suspended due to allegations that he cut off tether and contacted the complainant. Following that particular bond hearing, I instructed my client to not contact the complainant witness period in the jail. I also instructed my client that if allowed to be back on the bond, we would ask the court to hopefully to reinstate his original bond tether. We know judge that he has no prior criminal, well, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts, and obviously people address this. Some of the language that was used during conversations, I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contacted the complainant even after his bond. And so I say this, Judge, again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. He is.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something, it means it. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier bond that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. And so at the very least, the restriction on his phone privileges to contact family.
All right, well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become...
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, you know, and I get you're making the representation saying your client's going to follow what the court says, but...
The defense attorney is doing exactly what defense lawyers are supposed to do, focus on rehabilitation instead of punishment. But here's the problem. Promises alone rarely outweigh documented violations. Once trust is broken, convincing a judge to restore bond becomes an uphill battle.
I don't know if anything can be as shocking as walking into a court free, your bond gets revoked, you get put in jail because of something that you've done, and then you still go about violating the court's order. I-
I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns.
Listen carefully to the judge's reasoning. This isn't just about cutting off a tether anymore. It's about a pattern of ignoring court orders. Judges often forgive honest mistakes, but repeated defiance sends a completely different message. That's a huge distinction in the legal system.
And especially given the violent nature of this case as well.
Anything else, counsel?
I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out.
I guess that's not the quote, but
Yeah, it's close, but I did pretty good. I said it okay. Right now? All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. It's very about my child. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. So, again, please show mercy. Please. So, thanks.
These recorded jail calls may be the most damaging evidence in the entire hearing. Every phone call allegedly violating the court's order becomes another piece of evidence showing intentional disobedience. If you're the judge hearing those recordings, would you risk releasing the defendant again?
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir. Is all discovery complete?
And I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge.
Harry.
Notice how the judge shifts from frustration to warning. This isn't about winning an argument, it's about protecting the authority of the court. When someone openly challenges judicial orders, judges often respond firmly to send a message that court orders aren't optional.
Before Judge Perry.
And Your Honor, I did want to make the court aware, I did contact the jail yesterday, and they have blocks full of victims, new numbers and old numbers, so there should not be any more.
More calls coming through. All right. Thank you.
Thank you very much, guys.
Thank you, Your Honor.